I will call the Mandan Planning and Zoning Committee meeting of September 22nd to order. Roll call, please.
Commissioners Huber,
Here.
Langang, Horn,
Here.
Mutter,
Here.
Mayor Freilich, Commissioner Gardner,
Here.
Commissioner Renner, Commissioner Smith, Commissioner McLean,
Here.
Commissioner Intveld,
Here.
Commissioner Hammond,
Here.
Chair Robinson.
Here. And we have quorum. First order is we have a copy of the minutes from the August 25th meeting. Do we have any changes?
I can move to approve, Chair Robinson.
I'll second.
Motion by Commissioner McLean, second by Commissioner Infeld to approve the minutes of August 25th. Any questions? None. Roll call vote.
Commissioners Infeld,
Yes.
McLean,
Yes.
Renner, Gardner,
Yes.
Mutter,
Yes.
Horn,
Yes.
Huber,
Yes.
Hammond,
Yes.
and Chair Robinson.
Yes. Motion is passed. We'll move on to the first of our public hearings. Item number 1, consider a preliminary plat for Keitel South Hart Terrace, 5th edition, and a zone change from R7 to R32 and R7.
Good evening, Chair and Commissioners. We are requesting again that this be tabled until October. I think it probably needs one.
It is posted, so I'll open it up if there's any quick questions here. Any questions from the commission before I open it up?
I just have one, and I was reading it and it said it's minimum standards and maximum standards for the cul-de-sac, but I want to make sure that we can get our fire trucks and our buses, because I live in a cul-de-sac and it's bouncing off the curb and it costs the city already money to fix the curb in less than 5 years. So I want to make sure that that cul-de-sacs is able to fix or be able to get stuff around there. Thank you.
And I would have a point also. The suggested motion does indicate until the October meeting, and we had a similar motion last month. Should we state October or until both parties have completed their meeting?
I like that idea.
What did you say, sir?
Oh, I like that idea.
Okay.
Sorry,
Yeah,
didn't lean in far enough.
Yeah.
Any other questions from the commission? With none, I'll open it up for public hearing at this point. Do we have any questions, comments from anybody in the room?
Good evening, Chair and Commissioners. Abe Ulmer with ILSC. I just want to explain, we are working with the neighbor, same excuse we had last month. Working with the neighbor to try to solidify where our connection point would go. The grade is an absolute issue in that area. We've been kind of switching that around a little bit. Didn't want to cut 20 feet into the hill to try to make a road work. And so we're going back and forth with the other consultants trying to figure out exactly what's the best situation for both parties. So just wanted, that was the main reason why we're tabling it and pushing it down the road, is to figure that out a little more clear. So any questions for me? I can speak to the cul-de-sac. It will be designed as a 98-foot diameter standard, what's required by fire. So
Thank you.
yeah. Okay, thanks.
Thank you. Any other comments or questions? Item number 1. Comments or questions on item number 1? With none, I'll close public hearing and return it back to the commission.
Chair Robinson, I can make a motion. I move to recommend to table this preliminary plat and zone change request until both parties are in agreement, based on the conversation with the applicant and neighboring property, in order for both applicant to turn in complementary preliminary plats to address cross-connection concerns between the two parties.
I'll second.
Motion by Commissioner McLean, second by Commissioner Mutter. Motion is to recommend to table the preliminary plat and zone change request until both parties have agreed on the next meeting based on conversations with the applicant and neighboring property in order for both applicants to turn in complementary preliminary plats to address cross-connection concerns between the two properties. Any questions? Roll call vote.
Commissioners Gardner,
Yes.
Horn,
Yes.
Huber,
Yes.
Mutter,
Yes.
McLean,
Yes.
Intveld,
Yes.
Renner,
Yes.
Hammond,
Yes.
Chair Robinson.
Yes. Motion is passed. Second public hearing, consider a final plat for Call Addition. Rachel?
Chair, Commissioners. So this is a final plat for the Call IRA edition. We have had a name change. Let me get down to this. I apologize. There you go. So the Planning and Zoning Commission recommended approval of the preliminary plat and the master plan at the July 28th, 2025 meeting. The preliminary plat and master plan were approved by City Commission at the August 19th, 2025 meeting. The original subdivision name for the preliminary plat was the Call Edition. The September 4th, 2025 pre-planning meeting had a recommendation that the name be changed in order to avoid confusion with a similarly named subdivision. So that name has been updated, but otherwise there have been no changes since the preliminary plat, other than a couple small typos. They would record this with the master plan, and it'll go to City Commission from here if you make a motion to approve. And we would recommend approval. And I can answer any questions.
Questions for Rachel? Any questions for Rachel from the commission? With none, at this time, I will open it up for public comment. We'll take questions or comments on item number 2. Final plat for Call Edition. I'll call for comments or questions on the final plat for Call Edition. With none, I'll close. Return it back to the commission. Any questions?
No, I would move to recommend approval of the Call IRA additional final plat.
I'll second.
Motion by Commissioner Renner, second by Commissioner Intveld. Motion is to recommend approval of the Call IRE Edition Final Plat. Any questions? None. Roll call vote.
Commissioners Intveld,
Yes.
Renner,
Yes.
McLean,
Yes.
Gardner,
Yes.
Mutter,
Yes.
Huber,
Yes.
Hammond,
Yes.
and Chair Robinson.
Yes. And motion is passed.
Oh, excuse me. I have one more. I'm sorry. Commissioner Horn as well.
Yes.
Thank you. And the motion is passed. Third public hearing. Consider an amendment to a special use permit for Lot 1, Block 1, Bridgeview Bay Edition. Rachel?
Hey, Chair, Commissioners, sorry. Let me get down to my map here so you can see this. This is an application for an amendment of a special use permit for shop condos on Lot 1, Block 1 of Bridgeview Bay Addition. So this amended special use permit seeks to update the approved site, building, and landscape plan that was originally approved via a special use permit on September 17th, 2024. So this property is located at 2600 Marina Road Southeast. It's currently Zone CB, Business Commercial. So the existing special use permit was approved at the September 17th, 2024 City Commission meeting. So originally the application was submitted in December of 2023. It was recommended for approval contingent upon resolving site plan issues at the May 2024 Planning and Zoning Commission meeting. Then the applicant requested a variance at the August 26, 2024 meeting of the Planning and Zoning Commission. And in August, the commission delayed a decision on the zoning variance, which had sought a reduced width screening buffer between the property and a neighboring residential lot, which was required by the city's gateway and buffer ordinance. By September, the applicant had made changes to the site plan and a variance was no longer needed, and the special use permit was approved by City Commission on September 17th. So that special use permit allowed for the construction of multi-use shop condos. So they specifically allowed for 3 structures with 18 multi-use shop condos on the property. And I don't know that I have the original in here in an image. So I apologize for that. The 3 buildings had 1 structure with 7 units, which was the north unit, 1 structure with 5 units, which was the east unit, and 1 structure with 6 units, which was the south unit. And at the time, they intended to have 56 parking spaces based on the declared uses of retail and office. So the application showed on the south side of the property 30 feet of open space with 4 rows of conifers and a fence. The permit also required landscape buffering that adhered to the City of Mandan gateway screening requirement. They approved the special use permit contingent upon a stormwater management plan and city review of the condo declaration. So now this current application has a reduction in units, but we believe an increase in size to the units. And I say we believe for a reason. So the current application is what's in front of you. Let's see if I can rotate this. There we go. So the north structure has 6 units, so 1 fewer. The east structure has 6 units, so 1 additional, and the south unit has 5 units, so 1 fewer. The landscape buffer to the south shows 2 rows of conifers and 20 feet of open space, as well as a proposed fence. So while they're reducing the number of units overall, the building size, while not clearly shown, has appeared to increase on both the east structure and the south structure. We have not been able to review a complete landscape plan. This plan is not fully dimensioned and is really blurry, so it was kind of hard to determine what is going on specifically. But review of the plan that has been provided only shows meeting 5 landscape points, not 6, which is the required amount. The change in development pattern, even though that number of structures is less, is what requires the special use permit amendment. So the applicant did provide answers to the required questions with the special use permit application, which are in your packet. Staff has noted concerns regarding the applicant continuing to meet the requirements that were in the original special use permit. And we have requested a detailed landscape plan, but we have not been able to meet with the applicant prior to tonight. So we have not been able to determine if there are in fact buffer requirements that are being met. But again, our evaluation of the plan that was provided is that they are not quite there. So the recommendation would be that if approved by the Planning and Zoning Commission, the applicant would provide a detailed building and landscape plan prior to City Commission review. The adjacent properties, the current and proposed zoning is CB commercial and the property is within the Gateway Overlay District. Adjacent properties to the north are zoned RM, residential, and CB commercial and consist of a marina and restaurant. To the west, the property is zoned CB commercial. To the southwest is RM, residential, multifamily. And to the south, there are single-family homes zoned R7, residential. The future land use plan did recommend commercial development on these properties, and the proposed land uses have been declared to be commercial and personal, recreation, and storage. We have received one letter of objection, which is in front of you. We received that yesterday. I did email it to all of you as well. And then we did receive a phone call from that applicant as well. I believe both Jordan and I did. Or not the applicant, I'm sorry, the concerned resident. You do have findings of fact in your packet with a note that that staff has concerns regarding whether the landscaping plan fulfills the buffer requirements in the Gateway Overlay District. And then the recommendation, we recommend review of the special use permit for Lot 1, Block 1, and materials provided by the applicant and staff, future land use plan, zoning ordinances, and modifying or accepting staff findings of fact as necessary to support motion of the board, with any potential approval being contingent on requirements that the applicant demonstrate the ability to abide by all requirements of the original special use permit and provide a detailed landscaping plan to the city prior to final approval by City Commission. So that was what we wrote, assuming that we'd be able to meet with the applicant prior to this meeting and have a better understanding of what was going on for you. We haven't had a chance to do that. And so we just want you to be aware of that we really feel that this doesn't meet the requirements of the landscape code, but we just don't know for sure. So if you have any questions, I can answer them.
Questions for Rachel?
Chair Robinson, so give it to me clearly, because I'm a little bit confused. What changed from last year to this year? Or maybe I should wait for the applicant to come up? Like, I thought they changed the building size last year, and that's what we did. And I thought it went through ARC already for review, but I could be wrong.
Chair and commissioners, that is one of the things that we are also slightly confused about. We have gone through the minutes and through the approvals. And what we can find is what was approved was those numbers that I had put in the memo of, and I wish I had the original site plan, and I apologize for not having it in there, but the units were smaller. So these units that are on the site plan that is in your packet, some of them are like 2 units. So in that same space that you see 1 unit, it was 2. It was split vertically.
So the units changed from the original plan till now? Is that maybe
correct? Yeah, the unit numbers have changed, and they do appear in the south building to have gotten larger because they are. It's showing a 20-foot buffer on the south side where there was a 30-foot buffer. So the only place that we think those 10 feet could have gone is if the building got larger. But again, we haven't had the ability to confirm that.
Sure. Okay.
So Rachel, just so I'm clear, there's actually 2 concerns then. One is the landscaping, but then also there'd be the size of the building against what city code may be too. Is that right?
I guess I would assume that it probably meets city code based on the allowances within the code and the size and the parking. It probably meets city code, but yeah, we haven't been able to confirm that.
Okay.
Along those lines, so may I ask, would it meet the setback requirement with the 20 instead of the 30?
Chair, Commissioners, I'm uncertain.
And in reviewing Attorney Oster's letter, I'm assuming the footprint does cut into what was the intended buffer, if I interpret that properly. I don't think she's on today to explain her position.
Chair, that is our understanding.
I have one question. So the points, there's 6 points of the landscape points. So I'm guessing 2 of them are like 2 rows of trees. One's a fence. Do you know what the other You said there's 5 of 6 that they haven't met.
Unfortunately, I don't have those in front of me. I'm sorry.
Commissioner Gardner, I was just reading in Attorney Oster's letter in the bottom of page 1, last paragraph. It does also mention the separation between buildings, so perhaps that distance of separation is part of that.
Any other questions for Rachel?
Rachel, so basically, you're telling me you need more information to give us in the end run, right?
Chair and Commissioners, yeah, I would prefer it. To be able to really give you a good answer, a good clear answer of like, yes, this does meet, or no, this doesn't meet. I feel like I'm giving you a lot of I don't knows, and it is due to that lack of information. So yes, if we had more information, we hopefully would be able to be a little bit more certain in our evaluation.
So my second part of that question is, do you want us to deny this, or do you want us to table this?
Chair, Commissioners, I am not sure I have an answer for that one. I do know there's some neighbors here with comment as well, and I think the applicant is here as well.
Okay, thank you.
Just a quick question too. The minutes from when we approved the special use print, do we have those or the ability to get them? I know Nancy's not here and I don't want to, put Jordan on the spot to have an aneurysm or anything, but.
Chair, Commissioners, it sounded like the website was down.
I was trying to pull some of them, and if I can, I will.
Okay, thank you. Yeah. We can subpoena Andrew or have him come in too if need be. Yeah.
Yeah, we've had commissioners up here having trouble to sign in tonight also, so. Any further questions before I open it up? Thank you. With none at this time, I'll open it up for public comments and questions on item number 3.
Chair Robinson, Commissioners, I'm Wade Vogel. I'm here once again on this topic, and I apologize for taking up your time once again. Everything Rachel said was absolutely, I feel, correct. She is correct in that we're here requesting a little bit more space on building 1, while at the same time cutting some space on some of the other units. We were first here before you on May 29th, 2024 to request a special use permit, and that was approved. And I do have a copy of what was approved, what was submitted in those minutes and approved. Is that something that I could show? Building 1 is the south unit. 2 is the unit to the north, and 3 is the river unit. Okay. So in that application package from May 29th, when we were originally here, this is what was submitted. And as you can see, the numbers of units. And I'm sorry. And the X's are the units that we've deleted, and the lines, the dark black lines, are combining. The original, they were 2 units each, and they were combined into 1. And this did not have the specifics, if it was 15 feet, if it was 20 feet, but we had 55 feet, I believe, there originally. We had 58 feet deep there originally. We are now at 50 feet deep, so we've actually taken 8 feet off of that building. The building that was approved, though, at the city commission is one where there was only 40 feet deep on building 1, which is the building to the south. In order to proceed with the project, we were getting headwind from the former city planner, and so in order to move forward with the project, we moved that building back. We didn't move the building. We took it from 58 feet down to 40 feet, which gave us a 30-foot buffer there. And we removed the first unit on the south side on the river, which is this unit right here. And that's what was presented to City Commission, and that was what was approved.
So when we say we seek minutes, we should be looking at the city commission minutes, not the P and Z minutes.
Okay.
Does that make sense?
Yep, it does. So that's what was originally approved at Planning and Zoning, not at City Commission. That's correct. And when I say, when we went to the City Commission again, I had met with the former city planner, and we were told that the ordinance were going to be rewritten this past winter. And I think there was a very good effort to get that accomplished and to get that done, but I don't think it made it to the finish line. And so if the ordinances would have been rewritten to what we were led to believe, we wouldn't be here tonight because we would have met the criteria of the new ordinances. Again, that wasn't done, so we had to come back with a request to revise the special use permit. So what we're asking for now, am I doing that? What we're asking for now is to revise the special use permit to allow us to have two layers of trees on the south side and a fence, which, to answer the question, that's the 3 buffer points. We need 6 buffer points. So the ordinance as written says we can use 1 point for each 25 feet of separation between buildings. Between the buildings, we have 65 feet between our buildings. So we should at least receive 1 buffer point for every separation between those units. We did send a letter to the city and ask for Attorney Oster's opinion, and that's the opinion that was presented here earlier by Commissioner Huber. So to answer the question is, how did we get to 6 points? We have 2 rows of trees and a fence, and then we have 175 feet of separation combined between these units. So we're asking for some of that separation to be allowed for per the ordinance. The ordinance states buffer points must be satisfied through a combination of the following: 1 point for each 25 feet of separation between buildings, 1 point for a single row of conifers 6 feet in height, 1 point for a solid fence or wall at least 6 feet in height, 1 point for a berm at least 3 feet in height, 1/2 point for overstory trees, and 1/2 point for a hedge or shrub at least 4 feet in height. And we feel our proposed plat exceeds these requirements as laid out in the ordinance.
Would this be appropriate juncture to ask for clarification? It had been my understanding with regard to those buffer points that those were in reference to the subject building and the building on the adjacent property, not separation of the buildings within the site itself, because this is talking about buffering it from the property to the south or the residential building. So I think that would be the distance that would be pertinent here, if I'm understanding this correctly.
That was my question as well. That was what I was wondering.
Can I answer that? Commissioner Huber, you're correct in your assumption, and that's what we originally assumed also, that it was the separation between our building and the adjacent property owner's building, which is currently 75 to 80 feet. So we thought that we would get some points for that. And Attorney Oster said, stated that it didn't pertain to any units off our property. So the ordinance has to mean something. So it has to mean that it's the units within our own property. So instead of putting one ginormous unit there, we have 3 separate units, which gives us the separation. We didn't write the ordinance. We're just following the rules.
I still think it means, though, in reference to that property line, splitting those two properties, or in other words, the setback from the property that we're talking about buffering.
That's what we thought also. Any other questions for me?
Well, more maybe clarification, Wade. So the south, really in question is the building 1, the south one, the buffer zone between that and your neighbors to the south, correct? I mean, and at one point, take us back a year ago, we had that buffer, we got an exemption, it was here, it bypassed us, went to city commission, you got approval from that because what you and Andrew worked out previous planning and zoning. What did you work out? What was the distance between those two? How many points did you have at that point?
So we had 30 feet away. We had 4 rows of trees.
And you have now what? Wait, just so I get it right. So you have 30.
We have 20 feet, 2 rows of trees, and a fence. Oops.
So back when you got approved by ARC and city commission, you had 30 feet and 3 rows of trees. Now you have 20 feet and 2 rows of trees?
No, when we got approved by ARC, we also had 2 rows of trees and 1 fence.
Okay.
And I've got that with me too, if you want to see that too. This is what was approved by City Commission. And we had, again, we did that to comply with Andrew's request.
Sure.
That we have to have that 6 points on that south property line. But there's nothing in the ordinance that states that that we have. So there's nothing in the ordinance that states between the property line and our units, or the property line and the adjacent neighboring property. It just says that buffer points must be satisfied through a combination of the following. Again, it's probably not clear, but again, we follow the, I guess, the opinion of Attorney Oster. And her opinion was that we should get some points for separation of the buildings.
And you started building 1 already, right? Yeah. No.
No, building 1 has not been started yet.
Okay, that's what I thought, yeah.
And we do not have the South River unit started. We have a foundation in, but we did not proceed with that because we did not have a permit to build that unit.
Sure.
Any further questions for Wade?
I apologize. I'm just going to slow it down just a little bit. And
You're fine.
one more time, if you could go put that back on the board, the visual there. So this map right here has 4 rows of trees, and this was approved by City Commission.
That's correct.
And so in counting, there's 4 rows, so I'm guessing that's 4 points. You got the fence, that'd be 5. And then 6 is the distance? I mean,
That's correct.
okay. And then was this City Commission was approved last year then?
Correct.
And so, but now it's 20, and this, what was the distance on this one here?
30 feet?
30 feet. And now it's 2 rows, 20 feet. And you're saying that, I mean, you're kind of doing letter of the law instead of spirit of the law. Maybe spirit of the law, this is the way I see it. And not that there's anything wrong with it, I'm just,
That I'm trying to what?
that you're following the letter of the law, not the necessarily maybe the spirit of the law, is a couple of us commissioners have just assumed that's the way.
Agreed.
I'm not saying either.
No,
neither.
I have 100%. I'm just following what the ordinance states.
And Wade, you're going to do 2 rows of trees and the fence? You're getting 3
Correct.
points on that south side, right?
That's what we have. That's what we have on this plat.
That's what this
Yes.
plan calls for.
And we're not here to be bad neighbors. I mean, I don't know. If there's a different alternative or a different option, we're all for it. We've been here down this path for 18 months, and we're just ready to finish the project up. So
And somebody can remind me, it's 1 point for every 10 feet or
every 25 feet.
every 25? Oh, okay.
I guess it strikes me that the special use permit is what should be followed. And it seems like that would have stood even if there had been a change in the ordinance, because the special use permit would have preceded any change in ordinance, which hasn't occurred yet. So I'm not fully understanding the thought to change it.
Okay. Well, we were just coming back because we've not submitted for a permit for building 1 or for south unit on the riverside, which is considered unit 7. So per the city request, we come back for an amendment to the special use permit.
Chair Robinson, I guess that's kind of my take on this. I wasn't on planning and zoning when this was all started, but as that map is sitting right there, which was approved by the city, what was the impetus to changing it to 2 rows? Were you just trying to make the buildings bigger, or why are you trying to go from 2? Because in my mind, you've got 5 points right there. Plus, if you interpret it that the distance of 25 feet has to be between adjacent properties, you've got your 6 points. By removing 2 rows and making the buildings closer, you're losing 2 points right away, if I'm understanding this correctly. So what was the reason behind going away from this and going to 2 rows?
For a couple reasons. Thanks for the question. For a couple reasons. We originally, when we first came to planning and zoning, we were 58 feet deep there. We cut that down to 40 feet in order to address the concerns of the previous city planner, although we didn't agree with it. And we do have a legal opinion also from an attorney that shows that we were in compliance. We bypassed and did this just so we could continue on with the project without delaying it, because this was an October, November timeframe, and we didn't want to sit until this spring in order to get approval. So we went forward with this plan after talking with the former city planner, so that way we could get going, and it was agreed then there would be no rebuttal, and they would allow us to go through with buildings 2 and 3 as they sat here, and we would come back for building 1 and unit number 7 this year. And that was our intention. When we submitted this, that was our intention all along, to come back.
I don't, Commissioner Revener, was your question answered? I mean, I was kind of curious what the reason, I mean, the reason is that he'd like to get bigger space, I think is.
Yeah, I think.
Is that correct?
Yeah, bigger shop size there, and be able to add that unit on the river.
I guess I'm still, maybe I'm a little confused here too. If the intention all along was to come back, and if the intention all along was not to accept this, why did you accept this?
So we were asked to accept this because the ordinance was going to be rewritten. So when we came back, it was under my impression that when we come back, that we would have an opportunity to represent this. And maybe I was wrong in assuming that, but that's what we were told.
And see, that's where I would view that differently, that again, you'd entered into a special use agreement, and that's what brought about agreement by the property to the south. And so to deviate, that would deviate from the spirit of that compromise.
Okay. I don't think there was we compromised with the city because of the interpretation that there should be 6 units on the south property line, a buffer. We've since asked for a legal opinion from the city attorney, and the city attorney says that we should be able to have various ways of satisfying that buffer other than just all 6 points on that south boundary.
One other question, if we're done with that thought, is, so you said that the new ordinance was going to make this better. Do you know what particular points in the new ordinance would have alleviated were there less points that were required?
I think, and Jordan, correct me if I'm wrong on this, but I think it was gonna be more so that it was gonna be on a case by determined or looked at by the MARC, and I'm not sure if that's 100% correct, Jordan.
Yeah, commissioners, I'd have to go back and look and see what we have in our notes. Obviously, the intention was to have a new zoning ordinance, which we're still getting to. I would have to look up the specifics. I know there's still things we have in there for commercial landscaping and those type of things, but the specifics and I think how they correlate specifically to the gateway district is probably maybe different. But I there again, this would have been your guys' call as well to vote on the new zoning ordinance as well. So not in place yet.
Chair Robinson, I guess that's what I'm kind of hearing here, if I'm understanding all this, and I don't, like I said, I wasn't on the committee, so I don't understand what was being proposed to change the zoning, or not the zoning, but the ordinance from, before. And if you were under the intention going into this that there was going to be a zoning change, are we at a point right now where are we with this supposed zoning, or not zoning, but ordinance change? If there's something that's going to be coming up short term that it's going to be changed, I understand you're 18 months into this, you'd like to get going, but are we better off waiting until we get the actual ordinance in place instead of trying to make a variance on something that was already approved? I guess my question is, like I said, I understand you've got a lot of time sitting waiting on this thing, but would we be better off getting the ordinance in place first?
Commissioner Renner, the ordinance, I think, had Andrew not left, I think the ordinance probably would have already been voted on and whether approved or disapproved by this committee. The intent was, I think, this last winter, and then I think just with him leaving, and it didn't come to fruition.
Yeah, the schedule, I think, would have occurred probably sometime between this spring and now, actually.
I guess and maybe correct me if I'm wrong, if I'm misunderstanding this, but I do empathize with a business that's somebody who's trying to build something that you wouldn't want to wait another 6 or 9 months, freeze development, and waste time where you could be developing. That makes sense to me. I guess I wouldn't have a problem approving a variance if I knew that it was fulfilling the spirit of the ordinance instead of waiting for the ordinances to pass 6, 12 months, whatever it's going to take, and we hold them off for a long time. But I'd like to know that the spirit of the ordinances that were presented were going to be, that this would satisfy them. I guess that's where I'm at.
I think I'm going to have the craziest question of them all, but if we deny this, would you go back to your old plan to build?
We'd be interested in some sort of a compromise, yes. Whether that means we get to build unit number 7 along the river and we leave that 30-foot buffer on building 1, we're not opposed to that. I just think there should be some common ground, something. Again, we didn't write the ordinance, we're just trying to follow what the current ordinance gives us or provides for.
I know you're getting hammered, Wade. Thank
You're
you
fine.
for standing
I'm good.
up for the Inquisition. But I know that you got this submitted from the city attorney. Question 3, I think, bears summarizing. I think that's where you're saying you have approval, because she says halfway through the section, while the ordinance does not expressly state so, I believe that a reasonable interpretation would require a minimum of 3 points allocated to the screening between residential and commercial parcel. So you're thinking the 3 points are your 2 rows of trees in the fence.
Correct.
That's your interpretation, and that's what you currently have on the plan, and that's what you're saying. The city attorney is saying that this is okay.
That's correct.
Okay. And is there a compromise that could be, if you want that, instead of going the 20 feet and you want 25, to grab another point there? Is that, okay,
Be fine with that.
okay.
The other element here that I see is, there is a special use permit, and there's some detail in it, and the reason the attorney sent the letter is what's there does not follow the special use permit. So you got another, I don't know what comes first, special use permit or ordinance. And she isn't here to help us out, but
Commissioner Robinson, the reason that when we passed planning and zoning, we weren't automatically able to go to city commission is because it was stated that we didn't meet the criteria for the ordinance. So the ordinance must precede the special use permit.
Chair, Commissioners. Typically, your special use permit is not a variance. So a variance to the code would be changing the code or allowing someone to do something that specifically is not allowed by code. A special use permit simply allows for something that may work in a zoning district and may be compatible with surrounding uses as long as certain requirements are met. So in this case, it's not saying that they wouldn't have to meet the ordinance. It's just saying that they do have to meet the ordinance as well as other requirements in order for these shop condos to be compatible with the residential uses next door. So it's not an either or, it's a both, if that makes sense.
I know I said one last, but I'm going to do another last thing. I'm assuming you're not trying to break ground on building 1 right away. So if we were to table this to get some more information, you'd be okay for a month? Or what's your, yeah, I know. Build now, get it in the ground, right?
Well, the problem is I guess we don't live in Florida. So
right, yeah.
Already visiting with excavation and concrete companies, we're already on a very, very tight schedule, even if, because it isn't that it just passes here. I still would have to go to city commission and get approval there. And in between there, get a detailed landscape plan and these things put together for review by city staff. So,
and I think we called these different than shop condos. Didn't we call them like flex space?
commercial flex use spaces.
Correct,
yeah.
okay. I think Andrew came up with his own term for this or something. Yeah.
Yep.
Chair, Commissioners, they are listed in the special use permit as shop condos, multi-use shop condos. Yes, that's it. Sorry.
Thank you. Yeah. I just was trying to bring back my memory of everything, so.
Any other questions for me?
any other questions?
So again, I think it's just important to remember that this was a special use permit for shop condos to be adjacent to this residential property, and we've been coming up against these issues of kind of conflict between these different types of uses, not only on this project, but others. And so this was the agreed upon conditions to put those two uses adjacent to one another. So, for that part, then I think that all parties, I thought, entered into that agreement in good faith, and so I believe that it was a good agreement at the time and should stand.
Any other questions? Thank you, Wade.
Thank you.
Again, taking comments on item number 3.
Ramona Furlong, 2700 Marina Road, Southeast. I guess if there was a theme or a title that we would put on this agenda item, it might be been there, done that. We talked about this last year we talked about this a lot, and we went through the various ways that the buffer requirement could be met. Originally, the developers said, we can build right on the property line because we're going to use the distance between our building and your house as part of our buffer zone point system. And we said, you can't use our property to fulfill your buffer zone points. Then they said, okay, well, we'll seek a variance. Then they said, okay, well, we'll follow the buffer points in the ordinance. And they asked for the special use permit. Andrew doesn't have anything to do with it. This is an ordinance that they have to follow. And it's what's in place now. It might not ever be changed. And it's irrelevant about the talks that are going on about whether to change it in the future or not. We do have an agreement. They never said anything about, well, maybe we'll come back later and change it. In fact, they were upset because they said they didn't have enough room. If we have to have 30 feet of separation, we're not going to have enough room to have the size of units we want, to do what we want there. And we said, well, we're sorry. We want you to build on your property, but that's not our fault. They didn't do their due diligence. They didn't look at the easements. There's 2 easements that someone else owned a chunk of the property. That's just the start. They didn't know any of those things. So they had planned to build structures thinking they had more room to build than they actually did. And then when they found out they didn't, they said, oh, well, we shouldn't be the ones to bear that. Let the property owners to the south of us bear that. That's not fair. We talked to them. We got something worked out. We came before you folks. We came before City Commission. The deal that's in place is what was agreed to. We would object to anything that decreases any of the space between our property and theirs. Those buildings are monster buildings. If you stand on our property now, they tower over us. And now there's going to be another structure along the fence. It's like, okay, we agreed to that, but we don't want the distance shortened any more than what it already is. 30 feet doesn't sound too bad, but when you're standing there looking at it, it's like really close. And if they want to change that to 20 feet and the trees that they want to put in, my ashes are going to be blown in the wind before those trees are even above the fence. They're so small. So, the city attorney, she was the attorney last year when we were discussing these things. There's no letter from her there. And the buffer points, if she's saying that distance between their buildings and their property can be counted as a buffer between them and us, that makes no sense to me at all. And again, we have a deal, and I think the agreement should stand. Do you have
Any questions? Thank you. Again, taking comments or questions on item number 3.
A couple of other things that have come to our attention. The special use permit was passed with the list of conditions that we're hearing are not going to be met. For instance, there is supposed to be no overnight stays in the shop condos, and we're already hearing from a handful of people that they intend to live there over the weekends. So I'm interested to see how that is going to be enforced. There's not supposed to be any overnight parking. Those are the 2 that come to mind, but they're already not following all of the things that they agreed that they would follow. So the agreement shouldn't be changed.
Anyone else?
My name is Tim Furlong. I'm at 2700 Marina Road, southeast as well, and we're adjacent to the property. I think one thing that's important, and I brought this up before, is when we bought our property, which was 2011, we knew that there was a commercial piece of property there, but we also knew that there was this overlay zone that would give us some separation from anything that was going to be built there. So we did our due diligence, and I deal with land issues all the time, but I just can't imagine. It would appear to me if that gets changed now, it's almost a takings issue to us, because we bought our property with that in place, and assuming that that was going to stay in place between a residential and commercial piece of property. So I'm a little concerned about that there's even any talk about trying to change this overlay zone. And when we went to the city meetings last year, when Andrew was here, and we talked to him about some ordinance changes, he said that this would not get changed, this buffer zone. He said that wasn't even in a contention. So if something else is out there, we're not aware of it because it was never shown to us. So that's something new to us, that there was even a contemplation of changing that particular ordinance. Okay, any questions?
Thank you.
Thank you.
Any other comments or questions?
Chair Robinson, I guess I'm struggling with this a little bit. Which way is the right way? And I think, for myself, I think we have two options the way we are sitting at it, looking at it right now. We continue with the way it was originally drawn, with the 4 rows of trees, the 30-foot buffer zone, the fence. We can continue on with what was already approved by the city commission, or if the applicant is pretty much dead set on reducing that down to 2 rows and gaining that extra 10 feet, I think you almost have to take a chance and a gamble and try to push to change the ordinance to allow that. In my mind, that's kind of the two options where I think we're at. We either wait and change the ordinance, or we leave it the way it was already agreed to. Because right now, in my mind, to try to change the special use permit that is questionable if it's abiding by the ordinance right now, I have a hard time with that one. So I think I don't know if it's appropriate or not to ask Wade what his preference is, but I don't know if that's appropriate or not, but I guess I would like to kind of hear what you think on that, Wade.
Thanks for the opportunity. I do agree with Ramona that there is an ordinance on the record that's on the books today, and that we should follow that. And the ordinance that's there today says that we should be allowed 1 point for every 25-foot separation between units. It's not ambiguous. It doesn't say between the property line and the neighbors. Thank you.
On that last point, and maybe we need to get the exact ordinance in front of us, and I don't know if one of the staff could help with that, but I think it's just inherent. It's a buffer inherently between a commercial and residential property, and so I think if we can take a look at that wording, it might help. And then I think the other thing, maybe just to give some context for Commissioner Renner, any ordinance change that was referenced here would have been part of the overall zoning rewrite. And while we've seen broad strokes at that, we haven't seen any particulars yet as a planning and zoning commission. And so we wouldn't even be able to speak to whether or not the buffering between residential and commercial properties was proposed to be changed, or at least I certainly would not be able to. And I feel like I've stayed fairly abreast of the overall themes within that zoning code rewrite. And so personally would not be interested in pulling out a piece of that, but rather waiting until we get that overall code rewrite presented to us for consideration.
Chair Robinson, while they're pulling up too, I think that we can't base our decisions on what could happen in the future. We can't do that. If the ordinance changed, great, whatever, then we follow that rule. But we also don't know what's going to happen with these these shop condos as well, how they're going to be used or whatever. So we can't base our decisions on those either. I have a hard time. We don't have the city attorney here. She gave an opinion. It's written in from her that says that she feels like the buffer zone between the three has 3 points. She's very clear on that could be it. So I'm struggling with that. But we did change too. I think there's a compromise to happen here, but I don't know what it is. But I'd like to see what the exact city ordinance says. But her opinion, I mean, and this is our city attorney, states that there's 3 points allowed between the two properties. But
Go ahead.
Okay, we did pull up Jordan pulled up the ordinance. If I don't know if we can get it up on this screen. Yeah, it says buffer points must be satisfied for a combination of the following: 1 point for each 25 feet of separation between buildings, 1 point for a single row of conifers 6 feet in height, 15 feet on center. For example, 2 points for a double row, 3 points for a triple row, 1 point for a solid fence or wall at least 6 feet in height, provided that landscaping is installed between said fence or wall and the adjacent property lines, 1 point for a berm at least 3 feet in height, 1/2 point for overstory trees 30 feet on center, 1/2 point for a hedge or shrub at least 4 feet in height and 75% opaque. So I have a few items. I would tend to agree that the interpretation, while Attorney Oster's letter notes that those 3 points may be satisfied, that the separation between buildings is probably not on the property. It is probably between you're buffering between the two properties that you're attempting to buffer between. That would typically be my interpretation as a professional planner.
And Rachel, could you even lower that a bit to see what precedes that? Because I think we got to read, so we're talking about buffering between these different types of uses. So again, I think it has to be taken into that context and not isolated from that.
Yes. Yep.
Rachel, do you know, or what's the distance between the property line and the neighboring property?
I do not have that. And unfortunately, this is where when we were talking about like not having quite enough information, one of the other things that I'm noticing with this is it talks about the landscaping being installed between the fence and the adjacent property line. I don't know that that's what's shown clearly on that landscaping plan. So there are just some questions still, and I think that the previously approved plan was what was a plan, and that the city commission and the planner at the time felt met these conditions. But that would be, these are the items that are in the code. I would say my interpretation typically as a professional planner would be that between buildings would typically mean between the two uses that you are buffering between.
Chair Robinson, I guess that's what I'm kind of curious about without seeing where the neighbor's property, building actually is. Is it 55 feet from the property line? Because then that extra 20 feet gives you 75 feet and you've got your 3 points. If it's less than 55 feet, then they maybe do have to go to 30 feet. That would be kind of a nice thing to know.
But that would be back to the argument of using the neighbor's property as part of that, which it was meant to be, that 25 points from the property line.
Yeah, but it says buildings.
Although
It doesn't say from the property line. It says 1 point for each 25 feet of separation between buildings. So if you're going from their building to the neighbor's building and it's 75 feet, technically they've got 3 points right there.
Chair, Commissioners, from a professional planning standpoint, that is correct. I think if you look at the items above, some of those have 0 setbacks above, and so you may not always be able to so say you have like single family next to neighborhood commercial, and neighborhood commercial has a 0 buffer or a zero setback, right? And you needed a buffer between the two. I don't know what it is. I can't really interpret it. I can just tell you what the typical would be, and it would typically be between uses. I recognize that it does say building though.
Commissioner Renner, just for your information too, like I can look on, I have some things that can do that. It looks like it's about 57 feet between the property line and the neighbor's house. So I think that's what you're asking.
Yeah. And technically there is 75 feet then.
If we make an addition to the house, though, then you don't have the separation. That's why it generally is a buffer from the other property, so that we have the full enjoyment of our property.
I don't disagree. He asked the question, so I'm telling him how
I
I
don't
feel.
disagree either, but the way it's worded right now in that ordinance, it says separation between buildings. It doesn't say anything about property lines.
Well,
And to that point, that's why the special use agreement was reached and spells it out very clearly, and that is what the city commission voted on in August of 2024, and so it brought clarity to that issue as to what was expected.
I thought it was a little unfair to also use the neighbor's property as the buffer zone, but I guess as I think about it more, they both have the right to enjoyment of their own property and its own use. I mean, the commercial isn't trumped by the enjoyment of the residential that I'm aware of. So I guess if it's kind of who's ever builds first, I guess is the way it.
But the problem is that shop condos aren't permitted just by nature of the zoning. They do require a special use permit, and so that's why this whole discussion happened a year ago, and that's why that special use agreement was reached. And I guess so. On that note, to try to move this along, I'm going to move that we deny this application.
We're still open for public comment here, so have you hold for a minute. Any other comments? With none, I'll close the public hearing, return it to the commission.
Mr. Chairman, based on what we've heard in the information before us, I would move that we deny this application for a change in the special use permit.
I'm going to second that.
We have a motion by Commissioner Huber, second by Commissioner Hammond. If the motion is to deny approval of special use permit, Lot 1, Block 1, Bridgeview Bay Addition. Are you following the full recommended language here?
It looks to me like there's a typo in the recommended language, because you wouldn't have a denial contingent upon requirement that the applicant abide by all of the requirements of the special use permit if you're denying the application to change the special use permit.
I would agree, because if they're in compliant, then they didn't necessarily have to be here. So again, the motion is to recommend denial of the special use permit for Lot 1, Block 1, Bridgeview Bay Addition. Any questions?
I guess I'm struggling a little bit, like, I don't know if we have enough information. We even have Rachel saying she needs more information, and I don't know why we're going full for a denial right away, and why we didn't, even if I get it, time is of the essence for building, but I'd rather get this done right, at least get our attorney to weigh in a little bit and let Rachel do a little bit more research and bring it back next month and just table it until we can have a little better scope of it instead of denying. I struggle. Our city attorney is saying that this could potentially be okay, and yet we're denying it, and I don't know if that's the greatest thing we want to do.
I felt like things got turned real quick. All of a sudden, we're denying immediately, and I'm not necessarily convinced either way. To be quite honest, I'm still grappling with it all. Like, for example, when the 15-foot diameter of the trees, how do you get 15, it may be too much detail here, but how do you get 15, if that's the diameter of the tree and you have 20 feet of space? How do you get two trees? They're offset? Can you, like, how many can you get in there? I mean, quite frankly, I think the distance has been bothering me, the distance between the properties. I'd rather have the fence and the vegetation than the distance. I'd rather have that than no vegetation and immediately have parking lot and 60 feet of space, and then you have a building. So I don't think, I know the professionals are telling you how to add these points up, but to me, as I'm visualizing this, I'm struggling with, I really like the idea of a fence, some trees, multiple trees, 25 feet. I'm struggling a little bit with the visual of how that looks, but, and I just agree that there's just a lot of unanswered questions, but yeah, so that's what I'm at.
If you guys are going to table it, I think we should have a list of questions that
Well,
Rachel can answer for us, because I think I feel like I've got questions all the way around, but I'm almost willing to deny it, to redo it, to do it right also, because I feel like if we're going to just keep going back and forth here, next month, what are going to be our next questions? That's kind of where I'm at.
Chair Robbins, just a point of order. If we deny it now, is there anything preventing the applicant from coming back later? And
No.
saying this is what I want to do?
No.
I'm guessing there's some additional fees. Do we know what those are? How much?
I think for this one, it's like
$450.
$450.
I think we talked about this last year too, and let's get them in the room together. That's why we kind of did last time. Get them in the room together, figure out what works. And I think that's what they did. That's not what they did. Jim's shaking his head. He's like, no, I can't remember. Refresh my memory.
Commissioners, I believe the agreement that was done a year ago was putting the folks in together, and here's what was come up with. So that's what was done, and this is the agreement that was made between developer and the property owner to the south. So you can put them together again. I'm not sure you're going to have a lot of success in changing minds, but that's what was done.
I guess the one thing that I blame a little bit on the developer is that, we did have this last year, so there was plenty of time, and I feel like some of the rush that we're putting on now is due to the fact that this didn't come up in April or May, in my opinion.
Chair Robinson, just another, for my own information, there's nothing stopping, if they're denied tonight, there's nothing stopping the developer from going forward with what the plan was originally agreed upon from the city, correct? So he could actually start building that way tomorrow.
Okay, again, we have a motion and a second. Motion is to deny the request for a special use permit. Roll call vote, please.
Commissioners Huber,
Yes.
Veda, Hammond, excuse me,
Yes.
Infeld,
Yes.
Renner,
Yes.
McLean,
No.
Gardner,
No.
Mutter,
Yes.
Commissioner Horn,
No.
and Chair Robinson.
Yes.
6-3.
Motion is passed, 6-3. Any other items?
Excuse me. Commissioners, I just wanted to point your attention to the city website. And there are a few of you, not all of you, we obviously have them staggered, but boards and committees need to apply for renewals. I know there's some in-betweens and things like that, but if you'd go to our City of Mandan website, and this is for anybody watching as well, and you go to, oh man, I did it earlier. I've been to so many sites in here in the last 10 minutes. Give me a second. Committee board application. And if you click on that, it'll take you to this site, which will indicate which boards you are interested in. In this case, you'd be applying for the Planning and Zoning Commission. Give that a click. First name, phone number, email. Are you a resident, business, organization, functional? We try to make it super easy for you to apply, and you submit that, and that gets sent to the office. But we do have 2 of you that are up for renewal, and if you're wondering who you are, it is not you. But go ahead. No. Yes, Commissioner. It is Chair Robinson, and I also believe it's Commissioner Hammond, if I'm not mistaken. I'll have to look and see. Well, give me what's my paper say?
Gardner.
Oh, it is Commissioner Gardner. Excuse me, you are correct.
I only know that because I've been counting down the days.
So anyway, if there's anyone out there that wants to apply, or if you want to renew your application, fill out that on our city website. There'll be a bigger packet coming out here in October. But just a reminder to get that done before the end of the year so that we can get those people renewed and updated for the before I will look.
Watch for the email coming out.
Check it out. Yeah.
You'll tell us by next meeting, Jordan, whether these 2 both are reapplied.
Yes, we can let you know. Yes.
Chair Robinson and other committee members, I think is just a reminder that you may say, I'm interested, but you need to commit in writing to say, yes, I'm interested in another term, or if we hear nothing from you, we'll assume that you're not interested and therefore you won't be considered for another term. So you need to respond in the positive. So, and there will be an email coming out and a notice coming out the next shortly, reminding you of such and with a date that needs to let us know by X date so that that information comes to the Planning and Zoning Commission, then goes to the City Commission, and then you get your walking orders. Thank you, Commissioner McLean, very much.
That's it for us tonight.
All right, thank you. With that, I'll entertain a motion to adjourn.
So moved.
Second?
Motion and second to adjourn. All in favor, signify by saying aye.
Aye.
Aye. Opposed, same sign. We are adjourned.